Welcome, everybody. Thank you very much for joining this collaboration between Cornerstone Climate and Opportunity Green, discussing the key legal findings from one of the most exciting of the many exciting things in the climate legal arena that's happened this year, the International Tribunal on the Law of the Sea's advisory opinion on climate change and the maritime sector. And I'm incredibly delighted to be joined by two of Opportunity Green's leading members of the legal team, joined by David Kay, who's legal director at Opportunity Green with a focus on aviation, and Isabela Keuschnigg, who's legal officer at Opportunity Green with a focus on maritime. And we're particularly delighted that we've got this collaboration with Opportunity Green, who you may well be aware of as one of the relatively new but quickly leading voices in the UK in the NGO arena on, in particular, international aviation and shipping, but moving into other areas as well. For those of you who don't know Opportunity Green, it uses legal, economic, and policy knowledge to tackle climate change, and in particular by using legal innovation to focus on hard-to-abate sectors. International aviation and shipping being key ones, but also looking at, for example, steel, buildings, and shortly to move into agriculture and financing. So really tackling all the juicy hard topics all at the same time. And they've, if I may say so, shown an incredible track record of using their legal knowledge. So, for example, for the International Tribunal on the Law of the Sea process, Opportunity Green made submissions and they're available on their website. They've also made a submission to the International Court of Justice on its advisory opinion on the obligations of states in respect of climate change, which is well worth a read. May I just give a personal shout out to the Opportunity Green blog for your positive climate stories each month, much needed given the usual climate arena. So the way in which we propose to run the webinar is as follows. We're going to start off with Isabela, who's going to give us a high-level overview and a context of the advisory opinion, because maybe not everybody is as familiar with ITLOS and the underlying question and the jurisdiction as others. So Isabela is going to spend about 10 minutes giving us this high-level overview. Then David and I will come back in and we'll have about 15 minutes of conversation between us, where we're going to talk about some of our key takeaways, especially some of the more interesting legal aspects that we've picked up. And then hopefully that will leave us a good time for your Q&A. We've had a couple of questions come in already, but the Q&A function is open. Please note, as usual with these webinars, the chat function is disabled. So if you have a question, please pop it into the Q&A. I'll be monitoring and we'll try and get through as many questions and answers as possible towards the end of the webinar. Without anything further from me and leaving Isabela to do all the introducing of ITLOS and what has happened and the decision, I hand over to you.
Thank you, Estelle, for the kind introduction. It's a pleasure to be here. Let me see if I can, oh, there we go. So I'll provide a bit of a background of the advisory opinion before going into a high-level overview of key legal findings. So the request for an advisory opinion was filed by the Commission of Small Island States on Climate Change and International Law in December 2022, or short COSIS. COSIS itself was established in October 2021 at COP26. It's a collective of small island states which was founded for the development and clarification of international law in the context of climate change. And in its request for an advisory opinion, COSIS posed two questions to the International Tribunal for the Law of the Sea. The first question concerned the obligations of states to prevent, reduce, and control the pollution of the marine environment. And the second question, to protect and preserve the marine environment from climate change impacts. So we've got the first question broadly focusing on mitigation of climate change, and the second question broadly focusing on adaptation and resilience building. And in this webinar, we're going to focus mainly on the first question. In June 2023, there was a round of written comments, followed by hearings in Hamburg, Germany in June 2023. And in May this year, ITLOS delivered its landmark advisory opinion. This is the first ever advisory opinion on climate change and the ocean, and it clarifies the already existing legally binding obligations under UNCLOS in the climate change context. And crucially, really, the tribunal put a strong emphasis on the role of the best available science throughout the advisory opinion by referring to the authoritative assessments of the International Panel on Climate Change, or short, the IPCC, and really outlining the impacts of anthropogenic greenhouse gas emissions on the oceans, causing ocean acidification, warming, sea level rise, which in turn then endangers vulnerable communities around the world, but in particularly small island developing states. And in this respect, it's also well worth noting that the tribunal found that climate change poses a grave concern to humankind and also raises human rights concerns. And now turning to the key legal findings. So the first key legal finding was that anthropogenic greenhouse gas emissions constitute pollution of the marine environment, so fulfill this definition under UNCLOS itself. This is key because it unlocks the application of an entire set of obligations under UNCLOS in the ocean climate context. And while it's also remarkable to notice that most states actually agreed with this in their submissions to ITLOS, but it really dispels any doubt that this convention is not applicable in the climate change context. Further, the ITLOS then went to examine the obligations that kick in following this finding. And one of the key obligations in this respect is found in Article 194, paragraph 1 UNCLOS, namely that states need to take all necessary measures to prevent, reduce, and control marine pollution from any source. And while the tribunal found that this, in the context of greenhouse gas emissions, given the transboundary nature of such emissions, joint action and global action is really important, it also made the finding that this obligation cannot be discharged exclusively through participating in global efforts, and that states must take individual action as appropriate. In determining what all necessary measures mean, the tribunal also made clear that it is objective factors that determine the scope. And here again, we've already hinted at this in the context section, but the tribunal really put a strong emphasis on the best available science, so IPCC science, and the 1.5 degree temperature goal, as well as respective emission pathways. And this is really a guiding star throughout the whole advisory opinion. But also other factors matter next to the best available science, and these are relevant international rules and standards. And here the tribunal made clear that these are primarily those found in climate change treaties, such as the UNFCCC and the Paris Agreement. And here again, the tribunal pointed towards relevant standards, such as the 1.5 temperature goal and the timelines for respective emissions pathways, but also other environmental treaties, such as MARPOL for shipping or the Chicago Convention for aviation. And then crucially, the scope of this obligation to take all necessary measures depends on the available means and capabilities of states. This means all states must undertake mitigation efforts, but the scope of this depends. This means developed states must do more, both in terms of mitigation of greenhouse gas emissions, but also in terms of the support that developed states have to give to climate vulnerable developing states. And another key finding following from this was, and we'll touch on this later in more detail in our discussions, is that the obligations under UNCLOS are not necessarily satisfied by simply complying with requirements under the Paris Agreement. This is particularly important when taking into account some of the grossly insufficient nationally determined contributions that have been submitted under the Paris Agreement that will not make us comply with the 1.5 temperature goal. And this obligation to take all necessary measures is one of due diligence, the tribunal clarified, with a very stringent standard, given the high risks and the high risks of irreversible and serious harm that climate change poses to the ocean. And the tribunal also found in this regard that the precautionary approach applies, and this means that scientific certainty is not required for these obligations to kick in. And in the transboundary context, the tribunal also made clear that the standard of due diligence is even more stringent, given the nature of this pollution and that it affects the environments of other states. And then this is one of the key points of our discussion that will follow after this overview, is that the general obligation is complemented and elaborated upon by separate, additional specific obligations which apply to particular sources of pollution, including shipping and aviation. And while this is something that my colleague David will talk about afterwards in more detail, broadly there are two sets of obligations that kick in with respect to specific sources. And this is first the adoption of domestic legislation and establishment of international rules and standards, but also on the other hand, corresponding enforcement obligations. And the last point that I'd like to make in respect to the key legal findings is that the tribunal also noted that the failure to comply with the obligation to take all necessary measures could engage or would engage state responsibility. And while the tribunal did not further examine this in detail, this is given also the questions that were asked to the tribunal, this is something that we are expecting the International Court of Justice, the ICJ, to pick up in the advisory opinion that it is expected to deliver at the end of this year or early next year, given the questions that it is asked. And now I'll hand over back to Estelle.
Super. Thank you very much, Isabella. As we're running slightly ahead of time, I'm going to be a bit naughty and just ask you one or two follow-up questions. So the first question is really, this is a very interesting jurisdiction, right? Because the International Tribunal for the Law of the Sea is an independent judicial body. So it's got jurisdiction over any dispute concerning the interpretation or application of the UN Convention on the Law of the Sea, ITLOS. And it's issued this advisory opinion, which has, it's a terrible pun, but has caused waves. But so, Isabella, what is the binding nature of this? We're talking, of course, about international law. So we've got all those difficulties about international law, how it works. But you know, to how binding is this?
Thank you for asking this question. So an advisory opinion by nature is non-binding, but notwithstanding this non-binding nature, advisory opinions by international tribunals or courts such as ITLOS, but also the ICJ, carry great weight, both legally and morally. And so this is a clarification of obligations that already exist. It's a clarification and concretization. And first, the impact of this or the way that this non-binding kind of soft nature, the way that it could be hardened is also the way this will make waves. I will pick up on your pun, also in other realms. And for instance, given that the ICJ and the advisory opinion that the ICJ is expected to deliver, given that it is tasked to look at also marine pollution, also UNCLOS, we can expect the ICJ to pick up on this and make further remarks on this, but also this could really boost domestic climate cases around the world, which will focus on the ocean. And we already have cases that have been focusing on the ocean in domestic climate litigation. And this is, of course, guidance, top-down guidance, that arguments which can be used in these cases. So we are expecting this opinion to give a boost to climate litigation around the world. But also it has implications, and this is something that we'll discuss after, I guess, more, but for international negotiations, it can raise ambition, it can raise the bar, but also for domestic legislation. What we might see and what happened, in fact, after the Klimasenioren judgment in Germany is that legislative branches could be asking their governments if they're complying with their domestic legislation with international climate litigation, such as the non-binding advisory opinion. So I think the impacts we will see with time crystallize more clearly, but these are just some of the examples with which this soft, non-binding nature of this could be hardened.
Yes, it's very interesting, isn't it? And I'll shade this into the first discussion topic on the slide, which is the general obligation to take all necessary measures. Because, and I'll lead on this, but if either of the two of you would like to come in, then please do. The interesting thing, or one of the interesting things for me about this decision is, although it took place in what some may regard as quite a niche jurisdiction. So it's not very often that lawyers engage with the Convention on the Law of the Sea, and maritime seems to be quite a niche, quote unquote, area. But the interesting thing about the way in which pollution interacts with the ocean, in particular climate-related impacts on the ocean, seem to me at least to require that after this opinion having been given, seems to me to require states to take very significant action well outside what they would consider to be marine or maritime or shipping actions. So I'll say a little bit more about all necessary measures, and then if either of the two of you would like to chime in, please do. So as Isabella mentioned, the tribunal found that one of the key articles of UNCLOS 1941 requires states to take all necessary measures to prevent, reduce, or control marine pollution from any source. And that, of course, is including now greenhouse gas emissions and pollution from anthropogenic or human-caused climate change. And just to note, this is the first time, as far as I can tell, in the decision of an international body, in a legal context, that the decision-making body has said explicitly in terms, having looked through the science in, I mean, literally the first 66 paragraphs of this decision, guys, just read them. They are amazing. But having gone through all that science, the tribunal says in terms that the tribunal notes that climate change represents an existential threat and raises human rights concerns. So as far as I'm aware, that's the first time that a legal body has in terms expressed the danger from anthropogenic climate change as an existential threat. And then moving on from that and looking at the particular, what does it mean in order to take all necessary measures? Well, all necessary measures might not, as I say, not just be about reducing greenhouse gas emissions with sort of narrow actions that focus just on shipping matters. It may well be, depending on the nature of the greenhouse gas emissions and the impact that they have on the marine environment, it may well mean that states are required to take more wide action. In particular, though, looking at states' international law obligations, and as Isabella sort of suggested, taking all necessary measures must mean that at the very least, states are complying with their minimum international obligations for greenhouse gas emissions reductions, and in particular, those that have an impact on the marine environment. And one of the things that's been discussed, and it's something that I've been thinking about and looking at for some time now in terms of nationally determined contributions under the Paris Agreement framework, it seems to me that if international shipping and emissions in relation to international shipping and aviation are not included within nationally determined contributions, as many states say that they shouldn't be. There's legal disagreement about whether that's right or not. But I think in terms of one of the ramifications of this decision is that those aviation and shipping emissions are now, they should be required to be included within nationally determined contributions as a sort of basic mechanism for taking all necessary measures to address greenhouse gas emissions. There might well be a number of other aspects to all necessary measures. I I suppose with an eye on the time, I'll probably stop there. But David and Isabella, if there's anything else that you'd like to add in terms of what you think all necessary measures might mean, then please do chime in before we move on.
Thanks very much, Estelle. Nothing to add other than to say that I completely agree regarding the nationally determined contributions, and that probably segues nicely into a point that I was going to discuss next, which
Yes.
Is a question that I think might emanate to states in terms of compliance, which is where there are these international regimes, like in international shipping and in international aviation, what are their exact obligations, and how does that general obligation that you've described to take all necessary measures sit next to and relate to the more specific obligations that Isa outlined that apply to those sectors? So in more simple terms, I suppose, can a state simply comply with the specific obligations under UNCLOS that apply to vessels or to aircraft? And does that meet the threshold for also complying with the general obligation under Article 194? So those, as Isa said, those specific obligations include obligations that principally relate to land, air, and sea, and those are the three principal sources that the advisory opinion touched upon. And in respect of ships, the key obligation they looked at is to adopt laws and regulations that are applicable to their flagships, so states' flagships, which are at least as effective as the IMO rules and standards. So as Isa said, that's a minimum threshold, and states can obviously exceed that. In relation to pollution from the atmosphere, there's a separate specific obligation, which pollution from the atmosphere could include ships and aircraft. And that is to adopt national legislation which takes into account internationally agreed rules and standards. So that would include international climate change treaties, but also some of the rules and standards that come out of the International Maritime Organization, we'll call it the IMO from now on, and ICAO for aviation as well. So returning to that question about specific obligations, the tribunal said that they complement and elaborate the general obligation. So they sit independently but related to the general obligation under 194. That general obligation is common to all sources, so it applies as well to aviation and to shipping, and the tribunal said it needs to be met regardless of the specific source of the pollution. I think it's worth noting as well that as might be expected, the general obligation is wider than the specific obligation. So the court pulled out that specific obligation for flag states to regulate their ships, but the 194 jurisdiction and control point includes the exclusive economic zone and continental shelf of states. So that engages port state responsibility as well. So there are areas where the general obligation goes further and includes more in its remit than the specific obligation.
And David, just pausing there, for those who are less familiar with how obligations operate as a flag state versus as a port state, can you just give a little explainer about that?
Yeah, of course. So vessels will have their flag state, which is where they're registered, and that state will can introduce laws and regulations that apply to those vessels in particular. So those are the ones that, in terms of specific obligations, are regulated. I think it's Article 2112. They have to meet the minimum threshold of IMO regulations. And then port states, so states have jurisdiction to regulate vessels that are calling at their ports effectively. But those regulations can have effect outside of that, because if you require a vessel coming into your port to meet certain standards, then those standards would also apply naturally wherever that ship happens to be in the world.
And so do you see, just slightly provocatively, before I let you get back to your what you want to say, do you see that meaning that for port states, for example, if they could reduce greenhouse gas emissions by, for example, putting a fuel levy on ships coming into their ports, is that something that they are now, one, obliged to think about doing, or two, obliged to do?
Yeah, there's certainly obliged to, I would say, under the general obligation under 1942, obliged to consider that kind of regulation, because the tribunal was clear that the obligation to regulate emissions as it applies within things that are under the jurisdiction and control has an even more stringent due diligence standard than the general obligation to address greenhouse gas emissions. So because the port state authority gives those states the ability to regulate things that are under their control, so those ships that are under their control, then absolutely that is something they should have to think about. And there is obviously that higher standard of due diligence that applies to it. On that note, I'll wrap up there, conscious of time on this particular point. But I think, you know, returning to something Isa said about Article 194 not being exclusively discharged through global efforts, I think that's a key point for states to consider here when they're thinking about how to comply with these general and specific obligations and how that relates to their participation in ICAO and IMO. And in our views, simply participating in those global efforts to the extent they fall short of an objective standard that aligns with 1.5 degrees in terms of pathway and timeline and the best available science, a state cannot be comfortable that they have discharged those obligations.
Yeah, that's really interesting. Isabela, do you want to say a little bit more about that and the interaction between the UNCLOS regime and the climate change regime?
Thank you. Yeah. So something that we thought was really striking was the way that the tribunal, the interaction that the tribunal examined and clarified between UNCLOS and the climate change regime, because what states, or some of the states, tried to argue in there, both in the written submissions and also in the oral submission, was that only the international climate change regime should exclusively apply in this context. However, the tribunal made clear, no, these are separate agreements, the UNFCCC and the Paris Agreement on the one hand, and UNCLOS on the other hand. And in the context of greenhouse gas emissions and the marine environment, actually, these are complementary but separate agreements that both apply. So this was really important to make clear that to dispel the lex specialis argument, basically, that a lot of stakeholders were trying to make. And then what the tribunal also did is apply the principle of systemic integration, which is found in the Vienna Convention on the Law of Treaties. So it's a principle in international law, and meaning that it interpreted UNCLOS in the light of the prevailing legal framework. So the standards of the Paris Agreement, for instance, the 1.5 temperature goal, but also the timeline for emission pathways, it took those into account when, for instance, looking at the scope of the obligations under UNCLOS. So what does, again, what we discussed at the beginning, what does all necessary measure mean? How is it determined? So here we see an interaction, so interpretation of UNCLOS in the light of the climate change regime, but then also making clear that it is not enough to just comply with the procedural requirements under the Paris Agreement, to submit grossly inadequate NDCs, for example, and think that's it, you're done with your compliance with international legal obligations in the climate change context. And as you already mentioned, for instance, when it comes to international shipping and aviation, most states don't include those in their NDCs and in fact report these emissions separately, but doing so makes it a lot harder to comply with your obligations under UNCLOS, even though it's not an obligation under UNCLOS to submit an NDC. And now we're at a really unique point in time where the third generation of NDCs is coming up. These are due, I think I mentioned earlier, beginning of 2025. So it would be crucial for states to ramp up ambition, to include all emissions from all sources in those pledges under the Paris Agreement. So we thought that was really fascinating, the interplay between those regimes.
Yeah, it is really interesting, and it's going to, that idea of having an obligation that means that if you objectively are not aligned with the extent of the obligation, and while the temperature goal is is a goal, that's the way in which the international obligations are focused. If what it is that you are doing, and many countries still have a difficulty where there's a very significant gap between the policies that they have both domestically and, as you said, in their nationally determined contributions, and the pathway that's required in terms of reducing emissions to have any hope of meeting the temperature goal. So it's very interesting that that's one of the things that's come out of the ITLOS decision. Another thing that caught many people's eye, and mine included, is one of the conclusions that's made in the tribunal's decision that deals with environmental impact assessments and cumulative impacts. Have a look at paragraph 367 of the tribunal's decision. That's where it concludes on the first question and says that various articles of the convention impose specific obligations on parties to monitor the risks and effects of pollution, to publish reports and conduct environmental impact assessments as a means to address marine pollution from anthropogenic greenhouse gas emissions. And the tribunal goes on to say this in explicit terms: any planned activity, either public or private, which may cause substantial pollution to the marine environment or significant and harmful changes thereto through anthropogenic greenhouse gas emissions, including cumulative effects, shall be subject to an environmental impact assessment. Such assessment shall be conducted by the state party under whose jurisdictional control the planned activity will be undertaken, with the view to mitigating and adapting to the adverse effects of those emissions on the marine environment. So a very strong set of obligations there articulated around the need for environmental impact assessment. And in some ways, an answer to one of the things that is said in many areas, but in particular in the marine environment, where there's attempts to possibly avoid having to do an impact assessment, where there's this sort of drop in the ocean argument that it's such a small amount of greenhouse gas emissions that it couldn't possibly make an overall difference, especially when in the marine environment you're often thinking about not just domestic carbon budgets or reductions pathways, but international reductions pathways. And the tribunal clearly was not moved at all by the suggestion that the drop in the ocean argument was cogent in any way. And that's interesting to me also because, as Isabela mentioned, the Klimasenioren case, there too, there was an argument made about very small amounts of emissions, and that the court there was not interested or moved by the drop in the ocean argument either. In fact, it was highly critical of that argument. So interesting in relation to EIA and cumulative impact, standing back as to what that might mean for example, in the domestic context, if there's a plan or project and that's going to have an impact on the marine environment, and there's a greenhouse gas element to that. And of course, now we recall that the indirect effects from those greenhouse gas emissions are going to have to be included. So indirect effects of what the project or plan might be, including greenhouse gas emissions downstream. It'll be interesting to see how this determination by ITLOS feeds into any of the domestic understanding of how the EIA regime works. And in particular, cumulative impact assessment, because that's one of the areas of the domestic EIA regime that has been most difficult. And in particular, there's been difficulty around the way that cumulative impacts have been assessed for large infrastructure projects, in particular to do with road infrastructure. But I think the same it can be said for other infrastructure, in particular around aviation, that there just hasn't really been the type of cumulative impact assessment that some have been suggesting is required if you're going to get, as a state, any proper understanding of the extent to which either more emissions are being produced or emissions are needing to be reduced. And so various controls are required in order to achieve those emissions reductions. And one wonders in particular in the aviation arena for international aviation, what the impact is going to be on cumulative EIA. And anything from either of the two of you on the EIA point?
Just perhaps that this clear rejection of drop in the ocean and taking into account cumulative impacts, I think is a strong tribute to the science that the court took so much consideration of throughout the whole advisory opinion, because scientifically every ton of carbon being emitted into the atmosphere matters. There is no drop in the ocean from a scientific perspective. So this and it will be really interesting to see how domestic cases will deal with this going forward. But we've seen some remarkable developments in EIA cases in climate change litigation this year in Norway, the UK, of course. So it will be great to see how that develops further. Don't know if David wants to add anything, or Estelle.
No, I think you've covered that well. I think, yeah, it's as Estelle said earlier as well, it will be very interesting to see how this advisory opinion is used in domestic courts. So we're certainly watching that with interest.
Yeah, and there are some domestic decisions that recognize that every ton of carbon counts. So there's certainly something there to be engaged with. Anyway, David, over to you to think about implications for policymaking.
Thanks very much, Estelle. Yeah, so to return to our discussion around the International Maritime Organization and the International Civil Aviation Organization, obviously we've focused on states individually so far and what they can do unilaterally to meet these obligations, but that isn't to say that states shouldn't act jointly and participate in joint efforts. And indeed, the tribunal stressed the importance of joint actions given the global and transboundary nature of the problem we're trying to address. So states should cooperate to increase ambition and action, both at the IMO and ICAO. And indeed, there's obligations that were picked up in the advisory opinion to work to put in place international rules and standards and on a continuing basis. So this isn't an obligation that can just be met tomorrow. And we just wanted to pick up some of the policy implications and the kind of current outlook in both of those sectors. So the IMO is currently considering its basket of midterm measures to meet its revised greenhouse gas strategy. And that's going to be adopted next year. And then it will also meet to revise the strategy itself in 2028. So the important point here is that states will want to ensure that the measures under that strategy are sufficiently stringent, and also the strategy itself is sufficiently stringent to meet their UNCLOS obligations, so that they can be comfortable as well that they've met their individual obligations as states under UNCLOS. And for aviation, it's a similar point, but I suppose there's kind of less regulation being discussed, less to comment on. And whilst ICAO has a long-term aspirational goal of net zero, we don't currently have the measures in place to meet that goal. And current projections put the aviation sector significantly off course from a 1.5 degree pathway. So again, states will want to work to ensure that ambition and action at ICAO is lifted up and increased so that they can be comfortable that they've met those legal obligations.
It's very interesting. We have a question about the International Maritime Organization, so I might ask it now rather than holding it over to the question and answer session. And the question is how you see the performance of the IMO and the strategy for reducing emissions from ships.
This might be one that Issa is more competent at answering than I am, and neither of us are policy experts, and we've certainly got policy experts at Opportunity Green. But our understanding is that the current strategy isn't 1.5 degree aligned. So further work needs to be done to bring the strategy at the top level aligned with Paris, and then the measures underneath it to do the same.
Isabela?
Perhaps to agreed with what David has just said, but maybe to expand a little bit on that, is that in 2023, the IMO's greenhouse gas strategy was revised. It was a significant step up in ambition when compared to the initial greenhouse gas strategy. I think that should be acknowledged, but independent analysis has suggested that it is in fact not 1.5 aligned, which is very unfortunate. And at the moment, there are negotiations or upcoming negotiations which will deliberate the basket of midterm measures, as David has mentioned. These will include implementing measures in forms of a technical element or a fuel standard, as well as an economic measure, which potentially could be a global levy on shipping, but doesn't have to be. So it is now, and as David also said, the revised strategy, the next date for revision will be in 2028. But so there is a strong focus now on these midterm measures. These should be ambitious and 1.5 aligned, and taking into consideration the best available science to make sure that they can suffice the requirements under UNCLOS.
Yeah, that's, well, brilliant. Thank you very much, both of you. One of the interesting things for me about this decision is exactly what we've been discussing under a couple of these bullet points, which is that international action and the requirements to take international action on aviation and on shipping in particular, as areas where there is a requirement for international action in order properly for these areas to be abated. But that obligation does not displace, but sits alongside the individual obligations on states also to act, because in a number of arenas, and in particular in aviation, there's been a significant line of argument about how essentially the international arena displaces and means that certainly in certain types of decision making that one can't be requiring or suggesting that there should be individual domestic action being taken by the states, that it should just all focus on international. And I think this tribunal is a very good example of how those two things are not mutually exclusive, and how there is a requirement to act and to act with immediacy, both in the international arena and domestically. Do you think that there's scope as a result of the advisory opinion for any kind of legal challenge if down the line states fail, not in the domestic, which is, I mean, that's interesting enough, but imagine that states fail in their international attempts. So imagine ICAO never gets its act together, and we're 5 years down the line, we're no further forward. Is this a vehicle for actually bringing that somehow before a court? Easy question for you.
Yeah. Thanks very much. It's a really, really interesting one. I think you can see within the UNCLOS jurisdiction, within the competence of ITLOS itself, that the door has been left open to some kind of challenge. I think the tribunal was clear to largely steer clear of kind of issues of state responsibility, principally because it wasn't in the question that had been put to them. But they did nevertheless touch on it where they felt they had to. So it's clear that, and when they did touch upon it, they said, oh, well, we're notwithstanding issues that might come up of causation and other things, they've left the door open, I suppose, to a challenge for non-compliance. And I think that's a really interesting point in terms of at the individual state level. As your question relates, to the international level, I think I'd have to give that one a bit more thought.
Yeah, it's really tricky, isn't it? Oh, well, it's good that we have more things to think about. So just in the next 5 minutes or so, and then we'll throw the floor open for questions. So we've got one on the go at the moment, but please, if you've got your any other questions, do pop them into the Q&A. Looking at the outlook to other advisory opinions, we've talked about the International Court of Justice advisory opinion that's coming up, but either of the two of you, what would you like to say about the outlook to other advisory opinions?
Maybe just to quickly expand on the outlook to the ICJ advisory opinion, because that's what at Opportunity Green we're more familiar with because we made a submission. I think one of the points that was issued, in maybe careful criticism of the ITLOS advisory opinion, was that while ITLOS interpreted UNCLOS in the light of the international climate regime, it did not interpret it in the light of, for instance, the human rights regime. Although it did note, of course, that it raises human rights concerns, that climate change raises human rights concerns. What we might now see happen in the ICJ advisory opinion is being seen a strong emphasis on human rights law, given that international human rights law is one of the sources that the ICJ is tasked to look at. Also, it's being tasked to look at marine pollution and states' obligations with regards to UNCLOS, international climate change regime, customary international law. So I think we might see maybe the principle, or potentially, or what we're hoping it would be, that we see the principle of systemic integration being applied to look at the whole set of legal obligations under international law, and with a stronger emphasis on human rights law. So this is the first point. And then the second point is that, and David already touched on this, is that while ITLOS unlocked the door to state responsibility and liability, ITLOS was not tasked to look at these things. That's why it didn't elaborate on any of these things. However, the ICJ in question B that is being asked is being specifically asked to look at state responsibility and also the legal consequence if states fail to meet their obligations. So what we are hoping to see happen is that ICJ might open the door that ITLOS has unlocked.
Yeah, that's very interesting. And if there are others on the call who are interested in the Inter-American Court of Human Rights process, if you have a look on the Cornerstone Climate website under our international climate law work, you'll see that there's a link there to the work that some of the barristers at Cornerstone Barristers have been doing on the amicus brief that was submitted to the Inter-American Court of Human Rights, that looks at state obligations concerning climate change and human rights and responds to the request for the advisory opinion. And it's a very interesting read indeed. So I recommend that to you. Turning then, I think, to Q&A, unless there's anything you want to add on the last point, David.
Just one final point, and it's going back a couple of points, and apologies for that. But there's so much in this advisory opinion that we don't have time to touch upon, and that we could touch upon as well. But both Isa and Estelle have mentioned levies, and I think there's an interesting point for me here that the advisory opinion focused quite a lot on obligations that developed countries have to developing countries, and particularly climate vulnerable countries. And I think there's a policy opportunity here for states, because they've got these obligations to comply with in terms of providing that financial assistance and also regulating. And levies, maybe, I know there's this kind of global cause of growing for these two sectors that have traditionally enjoyed a very privileged kind of taxation regime. And people are starting to bring that into focus and think about the polluter pays, and whether that, should be, we need to make that principle apply in these sectors. And there's an opportunity there for states to combine or to meet the two obligations and use revenues from those levies to help support climate vulnerable countries. And I think that maybe brings us nicely back to where Isa started with this, which is that it was a coalition of small island states facing that existential threat that you described, Estelle, that brought this question to the tribunal.
Yes, and speaking of policy opportunities, I'll drop into the chat. Opportunity Green has just today published its briefing for policymakers based on the ITLOS decision. So have a look at that. I recommend it to you. We've got a couple of questions, so let's move on to Q&A. And the first question is about what triggers states' obligations to take all necessary measures. Is it the scientific perception of marine pollution or harm, an objective requirement? And what does the tribunal say about actual harm? So that's the first question. I'll pause there for answers.
Yeah, I think
I'm assuming that you're going to answer yes. Go on, David.
Yeah, is the question here? I'm assuming about damages, and I'm just looking at the time it was submitted. It's maybe something that we have touched upon in terms of state responsibility since the question was asked, but I think I think in terms of actual harm, there is. As we said, the tribunal didn't address it substantively, but it's quite clear that under the law as outlined by the tribunal, there would be the potential for that kind of claim to be brought. Whether geopolitically that is feasible or not, I'm not sure, but there is at least the open window for a kind of a state dispute to be raised before the tribunal. I'm not sure if have I adequately answered that question?
Yes, yeah, I think so. And we have been also discussing as we've gone through the scope of what international courts may or may not be able to do. So yeah, it is interesting that I think the tribunal tried to walk quite a delicate line, as you say, between not avoiding the question, but not answering a question that hadn't been asked. And so, as you say, it's quite a good metaphor, I think, describing the tribunal and what it did as leaving the door open for others who might walk through that door. Turning to the other question that we've been asked, it's about flag state control and port state control taking steps or reviewing their position. And the question is whether there is also an opportunity here for coastal state control where their sovereignty applies. I can't claim to know loads about coastal state control, so I'm going to hand that over to either of the two of you that wants to answer. Isabella, do you want to have a stab at that first?
Just to say that in our submission, and I'm happy to drop the link to the submission that we made last year to ITLOS, we considered the most appropriate control to be port state control. So we looked at both port state and flag state control, but not at coastal state control in detail. I don't know if David would like to add anything to that.
Just to add that in the tribunal's discussion of what comes within jurisdiction and control, they talked about aircraft and ships that are registered in a state, but they also talked about a state's exclusive economic zone and continental shelf. So I think you could infer from that is within the state's control and their jurisdiction.
Brilliant. Thank you very much. And I've dropped into the chat the link to Opportunity Green's submissions to ITLOS. It's a very good read. Can I also mention, and I meant to mention at the outset, I also recommend reading the UK government submissions to the ITLOS tribunal, because I had cause to read them earlier this year, and it's probably one of the most forward-thinking of the sets of legal submissions I've seen the UK government make around greenhouse gas emissions. And a lot is said in there on behalf of the United Kingdom as a state about what it considers in terms of greenhouse gas emissions and climate change that are very useful. And indeed, at Cornerstone Climate, we've been discussing for some time putting something out in writing about this. We will do when time allows. There is another question just in our last 5 minutes for both of you. Do you see policy opportunities nationally or internationally for pollution levies to support implementing more marine protected areas, including on the high seas, to mitigate and adapt to climate change and safeguard biodiversity, given that less than 3% of the global ocean is meaningfully protected? Great question.
I'm happy to have a go at this and then hand over to David. So at least in the shipping context, as we mentioned before, there's an economic measure considered at the moment as part of the basket of midterm measures. And as we said before, this could, but doesn't have to be, a global levy. Now, there's a lot of questions what this levy could look like. And one of the questions in relation to this possible levy is also, can the revenues of such a levy be used out of sector? So not just within shipping, but also, for instance, as the person that asked the question suggested, go towards marine protected areas beyond national jurisdiction. And that is a question that has to be clarified before then deciding where that money could go to and if it could go to out of sector. David, I don't know whether you would like to jump in on that, or Estelle.
Yeah, just to say, I mean, Belinda, it's a great question, and it's something we've focused due to time and because of what we're looking at in terms of shipping and aviation on the 194 obligation principally, but the 192 obligation, which we haven't had as much time to discuss, to protect and preserve the marine environment, clearly pulls in kind of resilience and adaptation actions, and the tribunal was clear about that there's, in terms of the high risks of serious and irreversible harm, states have specific obligations to protect and preserve rare and fragile ecosystems as well as species habitat. So we haven't really had time to kind of fully dive into that today, but I think it's a very good point that you raise, and it's something that states will have to think about when they're thinking about compliance with these obligations. They've got to think holistically about how they comply with those.
Yeah, absolutely. And certainly from my perspective, there's in terms of being led by the science, there's such a lot of scientific support for that intersection between the way in which the climate crisis and the biodiversity crisis are both informing each other and exacerbating each other. And I think in the context of a decision which is so driven by the science with the obligations that David has just been explaining, I think certainly there is scope. The door has most definitely been left open for this to be driving more biodiversity related matters too. All right, well, 1 minute to go, and time, I think, just for me to say thank you all very much indeed for joining us. We've had such an interesting discussion, and thank you very much to Isabela and David from Opportunity Green for joining us for this collaboration. In the usual way, the recording of this webinar will be made available, I think, either today or tomorrow, so that you can rewatch at your leisure. And we hope that you'll join us for the next Cornerstone Climate event. Also keep an eye on Opportunity Green's website, both for written updates and for potential events. But it falls to me just to say thank you all very much. Thanks as ever to Will, our brilliant marketing head at Cornerstone Barristers, for all his assistance with pulling today's event together. I hope you have an interesting afternoon, and I hope that you're making your own waves. Thank you very much, and goodbye.